In the workplace, we can look at the immigration rules as they apply to a non-US worker at three stages or in three different ways. Rules when we hire a non-US worker, rules in maintaining their employment, and rules in terminating their employment. A lot of the discussion on these rules has to focus on a type of visa called an H-1 visa, which is given to a particular set of employees, typically those who are professionals. I'm oversimplifying, there's a lot more here. But typically, what you are going to run into is most probably H-1B visas, which are physicians, professors, scientists, researchers, computer scientists, technical workers, engineers. All these people who are working in USA are probably on H-1B visa, also known as H-1 visa. The first rule that we need to worry about, or the first question we need to answer is, can you make an employee pay the legal fees and expenses? Well, employee comes to you and says, look, I want to get a visa, but I'll pay for it myself. Is it legal? Don't assume you know the answer. It is best to call counsel. The answer depends upon a lot of variables. It also depends upon what the current state of the law is. As you will see, the law has been evolving in this area. The answer depends upon the type of benefit being sought. Okay. In some areas, the laws very specifically say that the employers have to pay certain government fees and even some private fees. For instance, in a process called PERM, which is a green card process, immigrant visa process, the employer is required to pay for all expenses associated with a part of the process, including advertising and attorney's fees, by law. And they cannot recuperate those expenses directly or indirectly from the employee. It's illegal. On top of that, recent interpretations from the judiciary and from US Department of Labor cast doubt upon the legality of the practice of seeking reimbursement in general. Okay. For H-1 workers specifically, you cannot take any deductions or make deductions on their wages. That's a violation of the law by itself. The only deductions you can make are tax deductions, and those deductions which the employees specifically request, and they are being made for the employee's benefit. Get something in writing in those cases. Again, time to call somebody who practices immigration law, specifically employment-based immigration law. Another interesting feature of immigration law, employment-based immigration law, is that when we speak of salary, salary does not include benefits or variable bonuses. So you could have a situation where somebody is making $30,000 in base salary, but $300,000, which is not uncommon on the Wall Street, for example, in bonuses. The salary of that person is $30,000, not $330,000. Rules in recruitment advertising. In many cases, there are special rules, such as for green card applications, how you are going to place the ad, what should be the language, what you must state, what you cannot state. There are also special rules for H-1B dependent employers. Who are H-1B dependent employers? Those employers whose workforce is 20% or more. There's a calculation actually, but simple rule of thumb, 20% or more H-1 workers means you are an H-1B dependent employer. All of a sudden, you've got a slew of regulations to deal with. Not difficult, not too difficult if you know what you're doing, but impossible to try to figure out on the fly. Then there's I-9 compliance. I'm sure that people listening in know that whenever any worker is hired in the United States, no matter whether they are US citizens, immigrants, asylees, any worker, when they're hired, the employer has to complete an I-9. Okay. I-9 compliance, as I mentioned in the beginning of this conversation, I-9 compliance itself is a several-hour conversation. I really cannot get into the details. But the bottom line advice, if I were to give you one-line advice, it would be read and follow the instructions on Form I-9. If you have any doubts, get yourself over to one of your colleagues who practices immigration law, or or somebody who's well versed in immigration law. Then the last item that you want to look at when you are hiring a non-US worker, what are the documentation requirements? Whenever you hire a US worker, there are always going to be some upfront documentation requirements. Visas like H1, which I mentioned is visa for professionals, require quite extensive documentation. And we've given you some links in the handout that I've given you. For H1 compliance, you can copy and paste that link in your browser and go there. Of course, folks, you're always welcome to send us an email if there is any issue that you are not clear about. Okay.